Well, hello, everybody. Welcome to today's webinar, Legal Issues and Challenges in HR. This is a part one of a four-part series brought to you by the good people of the Chamber's Human Resource and Professional Development Committee, led by our chair, Tammy Davidson from Right Management. She's the Executive Vice President of Client Services, and her vice chair is Aaron Tandy from Boucher Brothers General. He's the general counsel there. Hey, listen, I want to thank you both, Tammy and Aaron, for the great job that you are doing and have been doing in leading this committee. Always full of exciting and chock full of incredible information. So thank you for all the work you're doing. Before I turn you over to Tammy, I did want to take just a second to make sure that everybody knew about the workforce development survey that we are doing, the Chamber's doing in partnership with FIU's George Perez Metropolitan Center. This is an extremely important survey. I've asked around, no one can remember when the last time that we locally surveyed the workforce needs, both current and future, from our businesses. Now, you all know the landscape in Miami has changed quite a bit in terms of the industries that are here. We've got a lot of tech and fintech companies. Many of your companies are leaning heavily into the technology sector, and the jobs we know are changing. Our universities, colleges, our workforce development organizations, our training institutes, they're all rushing to change their program, change their curricula to best meet those needs of the future. But they're using national data. There is no local data. And we all know around the Zoom room here that Miami truly is different from any other place in the country and probably the world. So it's extremely important that we gather and collect local data from businesses. We're trying to get 1,000 area businesses to really, and from varied industries, to really increase the power of the findings and the recommendations that can come from that. We are doing this through October 31st, the survey, and I'm really asking all of you to take the survey. It takes about 15 minutes. And while that seems like an eternity in today's fast-paced world, the 15 minutes you're investing here is going to save you and your company time in terms of finding right individuals and who are trained and prepared for your future jobs, particularly to the ones you're requesting. And then also, just save you time in terms of looking around in general, waiting for the right person to show up. So we really urge you to take the survey. Those of you who do, thanks to our partners at Royal Caribbean and Carnival, if you so choose, you can enter yourself into a raffle for 2 chances at a 7-day cruise anywhere in the world that the 2 lines sail. So, but in order to be eligible for the drawing, which will take place at our trustee luncheon on December 6th, you need to have your survey completed by October 31st. So that's really important. Again, I also hope that you'll take the link that will be provided and pass it on to your colleagues, to your friends, family members who are also business owners. We really want to get a very wide spectrum of companies and individuals who are taking this, so we have the best information, widest berth of industries that we can possibly have. Well, that's it. Hopefully you'll do that. I really appreciate all of your interest and help with the Chamber and all the work that we're doing. This is an important one. And again, can't thank Tammy and Aaron enough for the great job they're doing leading it. And so let me turn you over to your chair, Tammy Davis.
Alfred, thank you so much. You're so kind. And can I fill out the survey more than once to enter to win? I would love to have an opportunity of a 7-day cruise somewhere, which would be lovely. So, and I know this is very important work so that we are prepared in this community of what we need to do and where we need to go forward. And that's one of the things that we strive to do with the HR committee is we strive to educate the HR community and leaders in the community about what the latest things and I would say opportunities instead of challenges in our workplace and in our environment. And today, I would be remiss if I did not thank our sponsor, CareerSource. They are very generous and help us out all the time. And our Barry University sponsor, and the powers that put this together. I thank the Chamber for making this a wonderful opportunity for all of us. Without further ado, I want to introduce you to some very talented people. The first person that I really want to introduce you to here is Christine Shipley, who is one of the most dynamic people I know. She has been in human resources for, I'm not going to say over 20 years, but she is the Senior Vice President of AvMed Health Plans and for Santa Fe Healthcare. She's right here in South Florida and a supporter on our committee, and we appreciate her. She has expertise in strategy planning and leadership development, employee and labor relations. And that's why we thought that she would be a wonderful addition to this panel today, because she's designed performance management and training. And she has been previously in her career with Johns Hopkins Medical International and a leading role there. And then Constellation Energy, Baltimore Gas and Electric. She is got wonderful Masters of Science degrees, and we appreciate her being here today. Our other wonderful panelist here is Michael Bonner from Fisher Phillips. He is an extraordinary lawyer and he's an associate there. He has been working on labor and employment matters. He represents many people. He helps clients with state and federal laws and regulations and forward-thinking solutions. So he is has experience serving as chair in multiple trials, bench trials, and very experienced. And we are proud to have him from Fisher Phillips. And lastly, but not least, my wonderful colleague, Aaron Tandy, who has been a inspiration and a phenomenal force to help me from Boucher Brothers. He is an absolute tremendous asset to me on this committee. He is a knowledgeable lawyer. He was in his private practice and decided to go for a general counsel internal. And I think they talked him into it and got him to do that, and how lucky they really are. They are incredibly lucky to have Aaron. So incredibly lucky to have all of you. And at this time, I will turn it over to Aaron and let him get started.
Hello there, and welcome. As you heard, this is our first in a series of panels. Last year, we did a series of panels on elevating HR professionals to get into the C-suite with some of the techniques they need. But once they're there, they really need to make sure they keep up on the law, and they keep up on practices, and they keep up on the trends. Today, we bring you a series about the legal challenges and the changing legal landscape. There's a number of things we could have talked about in the state and federal space. We've chosen to concentrate on three things. Obviously, everybody, though, should be aware that on September 30th, the state of Florida's minimum wage went up to $12 an hour. That has implications for overtime for your hourly workers. It has implications for tipped employees. And as you know, based on a constitutional change here in Florida that the voters approved, we are marching to a $15 an hour minimum wage. So hopefully you've updated your records. You've updated, if you're using a computer system, you've updated the time cards and the process. That's always a problem, I must admit. And I sort of tee this up for people. The computer system doesn't always change over. And so when you're calculating overtime, that doesn't always change over. So for the first month, I would suggest that you review your paychecks, even if they're direct deposit, for your hourly workers, to make sure you're coding correctly. The fines the Department of Labor and the IRS impose can be hefty, even if it's an honest mistake. But today, we're going to focus not on new EEOC guidelines for assisting workers with challenges, but instead we're going to focus on three things. We're going to focus on the new Pregnancy Worker Fairness Act, the new standard for religious accommodations that has come as a result of last term's, the Supreme Court's decision in a case called Groff v. DeJoy, and the mandatory E-Verify requirements now in Florida, and a couple of nuances in using that system. So we're going to get right into it with the new Pregnancy Worker Fairness Act by a flip of the coin, as it were. Christine Shipley, who you heard is a senior VP at AvMed Health Plans, has agreed to lead us out on a discussion about what workers and employers can do to comply with this new federal standard. Christine, thank you so much for joining us. We'll get to Michael in a little bit, but Christine, please take it away, and thank you so much.
Great. Thanks, Aaron. Can everyone hear me? Let me do a sound check.
Yes.
Yes. Okay, great. So before I dig into the Pregnancy Workers Fairness Act, let me say thank you to Tammy for not actually citing how many years it's been that I've been in HR. I very much appreciate that anonymity. And with that, I will also say that having a full lifelong career in HR means that folks like Aaron and Michael have become my best friend. So as an HR practitioner, having a great labor attorney by your side on speed dial is probably one of my number one pieces of advice in terms of making sure that you're always being compliant with whatever the new legislation is that's coming out, because there's always something. Specifically today, as Aaron said, we're going to talk about the Pregnancy Workers Fairness Act. And this is quite new. It became effective June 27th, 2023. So I'm going to hit the what first. What is the act about? I'll talk a little bit about why it was enacted, give some examples, and then talk about what you can do to make sure you're compliant and enforce it. So today's, I think, as I was thinking about what I was going to be talking about and what Michael's going to be talking about, the key word for today, before we get to E-Verify, is accommodations, right? So this particular act is really about accommodations. There are a number of pieces of legislation out there, FLSA, FMLA, that deal with discrimination and deal with leave and time off. So those were kind of, as I would call them, in the bag, but there really wasn't a particular, an ADA existed, but pregnancy is not considered a disability under ADA. So there was sort of this gap that was out there. So enter the Pregnancy Workers Fairness Act. So at the end of the day, it requires covered employees, which are private and public sector employees with 15 or more employees, to provide a reasonable accommodation. Now, for those of you who aren't intimately familiar with ADA language, to make that simple, it's changes to the work environment or the way work gets done. So employers are required to provide a reasonable accommodation for known limitations related to pregnancy, childbirth, or related conditions, right? Unless the accommodations cause an undue hardship. There's another one of those key buzzwords that we'll talk about in just a second. So some of the key elements of this, here's my advice, right? As an employer, the head of HR, I recommend that you go into it with, how do I find an accommodation, right? How do I work with this employee to make sure that they can stay working longer? Because that's really what part of this is about. An employer can't force an employee to accept an accommodation. It has to go through the interactive dialogue process. Again, here's another buzzword, keyword from ADA. An employer can't deny employment opportunities based on the need to make an accommodation for childbirth, pregnancy, or related condition. And you can't force an employee to take leave if another accommodation can be provided. And this is kind of, motherhood and apple pie. You can't take adverse actions on terms or conditions and privileges of employment based on requesting or receiving an accommodation. So one might be thinking, okay, well, what kind of accommodations are we talking about here? So this is where I think, I'm a practical person. I always think specific examples really help bring this into context. They range. The accommodations can range from allowing an employee who might need to stand for their work generally to sit for their work. Allowing extra opportunities for them to drink water or have water available more often, closer parking. See, these are, you know, small, pretty easy on the one end of the spectrum. You get a little more complicated, you hit flexible hours, which can be challenging as an employer to accommodate, but still not considered an undue hardship. Additional break times for the restroom. That was a big one that was cited in a lot of the literature. Here's one that might be a surprise, is that an employee can be excused from strenuous activity that is part of their essential function, as long as the strenuous activity, it is presumed that they will be able to resume that strenuous activity within a relatively short period of time, right? Where under, yeah, so I'll stop there. Job restructuring. And again, like I said, the accommodations can range from sitting, drinking water, taking breaks, to restructuring a job. And then temporarily suspending requirements, assuming that the employee would be able to perform those requirements at some near date in the future. So to back up for a second, let me just talk real quickly about why this came into existence. Here's an interesting statistic which really hit home with me. In 2021, 66% of the women in the US who gave birth in the prior year were in the labor force. Right? So that's more than half the women who gave birth prior to 2020, the year prior to 2021, were in the labor force. Women are working later in their pregnancies, or they want to work later in their pregnancies. Financial pressures, single income earners, and so forth. There is a desire and a need for women to work longer into their pregnancies. And without the protection that this particular act provides, women in some cases had to make very binary decisions. They either had to quit their job, they might have had to been fired, they might have had to take leave earlier in their pregnancy, which means after childbirth, they don't have the leave they need for taking care of, you know, a newborn. And what happens is you have women who aren't able to remain in the workforce as long, or potentially at all. And so this law was really enacted to close that gap in accommodations, and then to provide that longevity further into the working careers for women. I mentioned there are some definitions, and this is key because Michael's going to talk about the religious accommodations, and they also use that term undue hardship and reasonable accommodations, but it has a new meaning, or a different meaning, under what Michael's going to talk about. Under this particular law, it reverts back to what those in HR and who practice HR a lot are familiar with, the threshold or standard for reasonable accommodations, for undue hardships, and interactive process, are all the ones that we've become familiar with under ADA. Here's the other piece of it. Generally, the studies that are out there show that most accommodations, and in particular ones associated with pregnancies, drinking more water, having more breaks, are relatively low cost. So the threshold or burden for undue hardship is much higher because the accommodations are relatively easy. And so the general expectation is that employers work with employees to have that interactive process to find those accommodations. The EEOC will start accepting charges under the Pregnancy Worker Fairness Act on June 27, 2023, as long as the behavior that is cited in the charge occurred after June 27th. If it occurred before, it has to be litigated or handled under another particular law. So the best advice for an employer is voluntary compliance. That means understanding what the law means, what it is that you might need to do, and participation in good faith in the interactive process to find an accommodation as quickly as possible for both the worker and for the employer to avoid long and costly litigation. Communication between the worker and the employee is key in the interactive process. And this is, I think, probably one of the other key things I want to leave this group with, especially in terms of leadership development and training, right? Because most of the times these requests don't come necessarily directly to HR. They come to their frontline manager. And so they also don't come in the form of, dear manager, I'm pregnant, please give me an accommodation under the Pregnancy Workers Fairness Act. I mean, that would be nice if they were that explicit, but they rarely are, right? They tend to come in the terms of expressing a need. I have a need to take more breaks. I have a need to be able to have more snacks during the day because my blood sugar or whatever. the employee doesn't have to cite a law. They don't have to cite the word accommodation. They don't even have to cite medical terms. They need to communicate a need. And because they have the threshold for the request is very low, meaning you make a request for a need, it's expected that employers respond. And so what's really important is that our leaders are trained to hear that this might be a request. And when that happens, making sure that they're connecting the employee to HR so that that interactive process can happen.
At this point, Christine, I'd like Michael, if he could give us, everybody's sort of familiar with the, accommodations that are used for FMLA leave when somebody is, on maternity leave. But Michael, if you could give us sort of the play between the act, both call it pre-birth and post-birth, I'd appreciate that. I think that would be helpful for the people who are listening, because I want to say, and I think you're about to say, accommodations don't just end sort of once the child has arrived, right?
Right.
And that's partly what the new thinking is moving forward with. So Michael, maybe you could take us out on giving us some of the other nuances before we move on. So.
Happy to, Aaron. And I just want to say thank you to everybody for allowing me to be here. I'm very excited to be here. Christine, I think, did a fantastic job explaining basically the ins and outs of the Pregnant Workers Fairness Act. Thank you, Tammy, for your wonderful introduction. And Aaron, I'm happy to answer your question. Everyone's very familiar with maternity leave, essentially time off, a mother or father takes for the birth of their child or adoption of a child. It can be paid or unpaid depending on the employer's policy. The Pregnant Workers Fairness Act, on the other hand, and I think Christine hit the nail right on the head, is it tries to fill in the gap between discrimination and accommodations that are normally offered under the ADA. And Christine also hit all the buzzwords, whether it's a reasonable accommodation. She provided some great examples, and the Equal Employment Opportunity Commission, which is the federal agency that handles charges of discrimination, whether it's gender, race, religion, whatever it is, they're actually in the process of proposing rulemaking and they're going to provide some examples of reasonable accommodations. A lot that Christine mentioned, as Aaron mentioned, the accommodations don't end once the child is born or adopted. That the accommodations can span afterwards. For example, providing a new mother with room for pumping or whatever it may be. They need to accommodate, provide reasonable accommodations to the new parent after the child is born, and it has to be, as Christine mentioned, reasonable. And unless it provides an undue hardship, and under the ADA, under the PWFA, an undue hardship is defined as significant difficulty or expense. So, and as Christine mentioned, a lot of the things, flexible hours, additional breaks to use the restroom, eat, to rest, being excused from strenuous activity, closer parking, things like that, flexible hours, those are relatively inexpensive. So it's kind of puts a pretty significant burden on the employer to show that this, whether it's, providing, allowing, a pregnant woman to get there late if she's experiencing some morning sickness or whatever it is, to arrive a little late, the employer's gonna have a hard time showing that creates a significant difficulty or expense to them. So denying, you have to be very careful when evaluating and these types of requests, because you don't want to make sure to stay in line with this new law, and it's definitely we expect a lot of claims to come up relating to this.
I'm gonna jump in here also to tell people, and I think you've heard from Christine and Michael, much of this is sort of also practical. So I'm going to give you an example from my company. So we have a cashier who's pregnant. Our cashiers stand. It just happens to be they have some responsibilities, not only to take money, credit cards, and for equipment and amenities, but also to possibly have to step out of where the cashier is located, which is a beach hut. For our employee who happens to be pregnant, the accommodation turned out to be a stool, right? So that while they were sitting or while they were in the hut, they could sit. That may sound really simple. It is. But sometimes the simplest things people have trouble with, right? And one of the things that we need to be clear about, and companies need to be understanding, is that the Biden administration has made it clear that before workers go off on MFLA leave because of a pregnancy, during the time that they're off, right, where they're covered by the older laws, most people know, and then when they come back for people who have to do lactation or they need some accommodation after they've come back from maternity leave, the expectation is that companies are going to make that accommodation, right? That we are in a, call it, more employee-friendly world as it relates to accommodations than we were 6 months ago. And that also leads into our second topic, which really is the change in religious accommodation. Michael's going to lead us out, but for those of you, just some background. Groff v. DeJoy was a case involving the United States Postal Service and an employee who wouldn't work on Sundays. You would think, well, no, the post office isn't open on Sundays, no problem, easy to accommodate. But in this particular case, that wasn't the case, because the United States Postal Service had a contract with Amazon to deliver, and we all want our boxes 24 hours after we order. And so the post office in certain rural areas fills in for Amazon drivers and delivers those Amazon boxes on Sundays. Mr. DeJoy did not want to do that. It caused certain hardship because, as you could imagine, where Amazon doesn't have drivers, there's not a lot of people, right? It's in the smaller communities that need the coverage by the U.S. Postal Service. And it was hard to get coverage for Sundays. Ultimately, Mr. DeJoy sued, and the Supreme Court took the opportunity to expand, as Michael's going to describe it, what employers need to do as you accommodate somebody who has a true religious or spiritual belief. Because remember, for those of you who pay attention in this space, even atheists, right, or agnostics are entitled to a religious accommodation under the law. So Michael, why don't you lead us out on this discussion on DeJoy, but also what employers should be doing now?
Thank you, Aaron. So yeah, I think you put it very nicely, that basically the underlying facts of the case. So what the employer here, the USPS, was arguing is that unlike the ADA for religious accommodations, the old standard to deny a request for a religious accommodation through undue hardship was that the employer simply needed to show what was known as more than a de minimis cost to deny a reasonable accommodation. The USPS was relying under the old standard and argued that essentially allowing Mr. Groff to not work on Sundays created morale and scheduling problems with other employees, as well as resentment towards management was the underlying reasons for their denial of his request for accommodation. The employee, on the other hand, argued that the standard applied to religious accommodations was too lenient, and it should be more in line with the standard used for the ADA, significant difficulty or expense. Basically, the employee argued that the USPS should be required to show the significant difficulty or expense to deny the request for accommodation, and that they haven't in this case. The Supreme Court ended up agreeing with the employee and finding that the higher standard applied. So now the standard, while it's not completely in line with the ADA significant difficulty or expense, the new standard following the Groff v. DeJoy decision requires the employer to show substantial increased costs in relationship to the conduct of its particular business. So it essentially becomes a very focused case-by-case inquiry that requires the employer to be able to show that they're, based on the employee's request for accommodations, they're going to suffer significant costs in their particular business. Now, I think, as you know, the most helpful way to explain the practical effect of this is to say that under the old standard, you know, when you call me about a religious accommodation request that you're evaluating, it's usually a pretty short phone call. It would be, well, do you have a legitimate business reason to deny this accommodation request? And the answer is normally yes. You can come up with something. And for example, the USPS was saying, oh, resentment towards management, scheduling issues, things like that. You know, very easy, very simple. Okay, so we can deny that request. Now it becomes a more complex business-focused inquiry that'll require a lot more than just a quick phone call. You're gonna, the employer, when evaluating these requests, is going to have to determine and be able to show before denying the request what cost or what significant cost to their particular business will the company will accrue if they accommodate the employee. However, it should also be noted that the Supreme Court did leave open the impact of on union or collective bargaining requirements. So that is something that's going to develop here in the future, as you know, more claims are brought following this this Supreme Court decision under the new standard. There's also some remaining questions about retroactive effect of the decision. And you know, on that note, to be safe, I would recommend going back and revisiting prior requests for accommodations over the past year to see if there's anything you can do to accommodate these, because the last thing you want is an employee saying, oh, I requested, you know, a room for you know, prayer, and that was denied to me. And then, you know, maybe you're running afoul of the new law. And on that note, some of the examples of types of accommodations that are likely in line with the Pregnant Workers Fairness Act, you know, things that will not cost the company significant expense that should be expected to be accommodated, are, depending on the employee standards, but appearance, wearing headdresses, growing beards, rooms for prayer, days off for religious observance, things like that. I mean, those are going to be a lot more common now because, you know, people are going to know that the employer is going to have to show a lot more than just saying, oh, this is going to cost us a little bit of money, or this is going to cause some inconvenience to deny the request. And
that really leads to a really good point that you make, Michael, which is that companies really need to go back and look at their policies and update them, especially when new decisions are made or new laws are made. And Christine, can you know, from the business point of view, since you're embedded at a company, what do you do when these new laws come out? Do you go back and revisit your policies? Do you send out updates? How do you address that?
That's a good question. And before I dig specifically into that, let me point out one thing that was a surprise to me. And I think it was Judge Sotomayor's opinion, where she said that an undue hardship, it didn't count if the undue hardship was on other employees. And that is a big distinction, right? So an undue hardship for a company versus an undue hardship for other employees. And in this particular case, they were claiming the other employees were being forced to work overtime or days that, you know, an extra day a week. And in the past, HR practitioners, if we had something that caused undue hardship on other employees, which then affected morale and turnover, we would say that was an undue hardship. So that standard has changed. So one of the important things, just like I talked about with the Pregnancy Workers Fairness Act, one is to make sure that our policies are updated. So we do that at least once a year, but then also as we get information from our legal counsel, we'll go back and check any policies that need to be updated. But then we have leadership development training where at least once a year, we're bringing managers and frontline supervisors together and talking about important things they need to understand when managing the workforce, i.e., if somebody needs a religious accommodation or they ask for something and it, you know, you're not sure what to do, make sure. And most of the time we're saying, come back to HR because we'll provide the guidance on how to respond in a way that keeps us out of trouble.
And Christine, to follow up on that, I actually prepared for my firm an insight, discussing this decision and providing some practical advice for HR professionals. And I'm going to put the link in the chat here. So if
Great.
anyone wants to learn more and learn more about what you can do to prepare for, these new changes in the law, feel free to look it up. And, in addition to the Pregnant Workers Fairness Act, if you want to sign up for Fisher Phillips Insights, we stay up to date on developments in new laws and that affect HR professionals all the time. So I would highly recommend doing that to stay up to date and ahead of these changes, to not run afoul of any new laws and new developing laws.
So what Michael's
Before-
going to post is a gold mine. It's a gold mine. Take advantage of it.
Right. And before we switch, I just want to say we did have a question in the Q&A. So they asked for the site. The citation for the DeJoy case is 600 US 447. It was decided on June 29th, 2023. I also want to point out, and the theme here that you're going to be seeing, I think, in the HR space as we talk about accommodations, and really started, I think, with the Bostock decision. This is my own thought, but bear with me. Is when that decision talked about the need for reviewing the impact on the individual employee, not on the workforce in general, not on the employer in general, right? The decision that in Bostock, focused on, was the individual employee experiencing a discriminatory conduct? And if so, then the Title VII Act was triggered, and therefore there was something that needed to go. I think you'll see in both the Pregnancy Worker Fairness Act discussion that Christine made and in the religious accommodation, and we're not sure where the EOC is going to give us in terms of guidance, but what Michael was talking about is it's an individual review of the individual employee's request for the accommodation, not how it affects other people in the business or how it might affect the overall impact. So years ago, as we said, we used to say for an ADA accommodation, I don't have to build an elevator to get an employee who may have broken their leg from the first floor to the second floor if all I have is stairs, right? But if I have an elevator, then I have to make it available regardless of whether or not it's only the president's elevator, because I've got to get that employee to their job. And that's really now that standard. What are we doing for that individual employee to get them back to work is really the overall theme, I think, that if you take nothing else from the discussion that Christine and Michael have made, is happening here, right? The theme is, how do we get the individual employee back to work? And what does that individual employee need to return to work? And because of that, I think you're going to see more requests for accommodation, especially also, and we're not going to touch upon it, but for people thinking ahead, as we have an older workforce, menopause accommodations are now a big thing in England. They're moving across the pond, as they say, and we'll probably be dealing with that. Other accommodations, again, that people will be making, especially unfortunately with the COVID rise in COVID, people making religious accommodations. Prior to DeJoy, that was an easier decision or discussion amongst our HR teammates and the outside counsel. Now I think there's going to be a much more nuanced discussion. That doesn't mean that protecting your workforce means that you have to abandon the standards. I just think it means, as Christine said, when these decisions come out, you need to be clear about how you are, I guess I won't say imposing, but what the lens you're using to make sure the standards are going. With that, I'd like to switch a little bit and talk about basically E-Verify. Hopefully everybody on this call is using E-Verification. E-Verification has been required here in the state of Florida I think, earlier this year by state statute. I believe it was in June. E-Verify, for those of you who are unfamiliar with it, but hopefully you're not, is an internet-based system that compares information entered by the employer from the I-9 form across records from the United States Department of Homeland Security, the Social Security Administration, and other databases to confirm that the person's documents are true and correct. It is supposed to be helpful to weed out forgeries. It is supposed to be helpful to weed out those people who unfortunately are here not legally. I hate the word illegally, because obviously lots of people who are here under DACA didn't necessarily have the choice to come across the border. So I think there's a different word we should be using. Illegally has criminal connotations. I don't think lots of the people who are applying for jobs, it's just my own view. But with E-Verify, there's also an overlay. That's a federal system. Florida is now mandating it, but Florida has its own overlay that people should be aware of. There are certain states whose documents are to be looked at even more closely. Those are the states of Hawaii, believe it or not, Connecticut, and Delaware. Used to be also included Rhode Island and Vermont. The reason for that is that the Florida Department of, believe it or not, Highway Safety and Motor Vehicles, gives us our driver's license and verifies other states' driver's license, believes that those states issue not just driver's license, but what are called identification cards. And that sometimes those identification cards are given to people who may not be here in the country. Coming from those states or using those state documents, please look. I muted myself. Please look at them more closely because it's important that you don't run afoul of Florida state law. With that, I don't know. Somebody asked if we will receive a recording of the webinar. A recording will be posted. Let me just see, I'm looking. Yes, so I think I just said, somebody asked a list of driver's license not acceptable in Florida for I-9. So let me be clear about this, okay? E-Verify is a system that is using documents we've all used before. Previously, we could use paper documents and we could simply verify on the I-9 form. E-Verify makes us use an electronic system, but the same documents exist. Driver's licenses, passports, green cards, all of those documents that people use to identify Social Security cards, to identify their right to work in the United States, are used in the E-Verify system. The point I'm making about it's not driver's licenses, it's identification cards. They look very similar, okay? They look very similar. They are not, let me be very clear here, the states that are issuing them, Connecticut, Delaware, and Hawaii, that used to be Vermont and Rhode Island, and they may still do this, issue what is called an identification card. It says that you're a resident of a particular state. It doesn't say that you have a right to drive a car or drive a truck, or it's a motorcycle.
Did Aaron freeze for everybody?
Yeah, I believe he did.
Okay.
Yeah, so just to kind of continue on the E-Verify.
Okay, did I miss? I don't know where I came to. Can everybody hear me?
Yes.
Oh, there you go. Now you're back.
Okay, so I don't know where I ended, so I'm going to repeat for the question. The question was list of states where driver's licenses are not used for I-9s. That's not the right question. I apologize if I was imprecise. There is a difference in driver's licenses and identification cards. Florida does not have a difference. We only issue driver's licenses. Driver's licenses are used to show proof of residency. But in certain states, they will issue not driver's licenses to people, but identification cards. They look somewhat different than a driver's license. So this is not a question about a forgery, right? My company, we get sometimes people who are underage who want to use their brother's license. And so we have a forgery situation. That's not what I'm talking about. Identification cards are different. Previously, here in Florida, it was legal to use identification cards, regardless of the state that issued them, as a form of identification. That is no longer the case. Here in Florida, if you get an identification card, which is not a driver's license, from Connecticut, Hawaii, or Delaware, they cannot be used as a form of identification. That's the point. It's not a driver's license. I hope that's more clear. Let me just see. I don't know in our chat if we have any others. So I want to leave, if we don't have any more questions, I do want to leave for last comments. So since Christine went first at the beginning, I'm going to ask Michael. Michael, some last comments for the webinar, and then I'll ask Christine, and then we'll have some final thoughts. And if we get another question, we'll tee it up.
Yeah, thank you, Aaron. Yeah, I think that was a very good explanation of E-Verify and things to be aware of. I will also say, so the way E-Verify works is, it checks with the Social Security Administration and the Department of Homeland Security records to compare the information in the I-9. And what E-Verify will do is provide you a response. It'll say either employment authorized, or sometimes you'll get a response that says tentative non-confirmation. If you get a TNC response, tentative non-confirmation, the employee will have 10 days to contest the filing. The employer needs to be very cautious, however, that there's a couple of things you cannot do with E-Verify. You cannot pre-screen employees using E-Verify. You also cannot take action against an employee who receives a tentative non-confirmation determination. So you have to kind of let it play out. You can't just say, oh, they got a tentative non-confirmation determination, we're gonna let this employee go, we don't want to deal with that. You can't do that. Another thing very important to be aware of is that E-Verify laws are still being fine-tuned. There's current discussions about tweaking the statute, and I'm not going to offer any guesses as to what they're going to do, but it's very important to stay up to date. The last comment I have is, and worth noting, is that the department that's been charged with investigating E-Verify investigations is the Florida Department of Law Enforcement. So just be aware of that. No one wants to receive a letter from the FDLE, but if you do, it's likely that this is going to be what it's about. And Fisher Phillips has handled several of these investigations recently and will continue to handle more. So if you ever receive a letter like that, keep us in mind, because we're happy to assist you.
And Michael, let me just throw this out there. E-Verify does not replace the I-9 process.
It does not.
It does not. It is separate and distinct, and in addition to.
Correct.
Right.
And it's just meant to compare the information. So what the employer still needs to work with the employee to fill out the I-9, gather whatever documents are necessary, and then the employer needs to submit the I-9 information using E-Verify within 3 business days of the employee's start date.
Aaron, do you want me to go?
Yeah, please do. I'm actually typing. Somebody asked for the list in the chat, so I'm putting the states in the chat, even though I've said it several times. So
Okay.
and then I'll close. So go ahead, please.
All right, thanks. So I think just in summary, if we think about, in particular, the first 2 items that we talked about with the Pregnancy Worker Fairness Act and with the religious accommodation, again, the word is accommodation, and treating each situation on a case-by-case basis, having the discussion, evaluating the factors, the impact, and making the best good faith effort to accommodate, because that is, as Aaron and Michael have talked about, that's really the direction and the sentiment of where we are right now. And that's what the courts will be looking to see that employers are doing. If you're interested kind of, because there's a lot of different pieces of legislation that affect someone who is pregnant or nursing or returning from leave from childbirth. So FLSA has provisions in it which have been further broadened by the Pump Act, which was just enacted in December of 2022. So you might want to familiarize yourself with that, but basically it requires that an employer give breaks to a nursing mother for at least a year after childbirth, and whenever they need to pump, and in a private space that is removed and not visible to others. So that act kind of works in conjunction with the FLSA. Title VII is really on the discrimination side. And then you have ADA, which again protects for disabilities, and there are disabilities associated with pregnancy or post-pregnancy, and that would be part of what falls under ADA. And then FMLA is really all about the leaves. So just keep in mind all these kind of work together, and you can't take anyone in isolation. You kind of have to look at how they all fit together and which one applies given whatever particular circumstance you have. And I'd like to thank everybody. It's been a pleasure, and let me turn it back over to Aaron.
Great. So I'm going to end. Somebody had a question in the chat about about the government requiring employers to provide part-time employees ample notice in terms of work schedule for caregiving. There are a number of caregiving or policy questions that are being bounced around at the Department of Labor. That's one of them. On the flip side, that's for people to come back to work so that they can set up care for their children. The other thing that's going on is the other way, right? Under FMLA, you can take FMLA leave to care for a sick relative. And so there's some question about making sure that people have enough accommodation time to accommodate their caregiving schedule if they're the actual caregiver. Both of those things haven't yet come out in terms of an actual policy. So we'll be looking at it. For those of you who pay attention in this space, you do know that there has been some question by the Department of Labor to increase the wage requirement for somebody to be exempt. That's still in the discussion phase. That proposal was lofted, that balloon. Comment period is still active, so we don't know what's going to happen with that. I will point out that the last time that an administration tried to raise let's call it the weekly rate for an exempt employee significantly, there was a lawsuit. This was under the Obama administration. Those of you who pay, in this space will know that the Fifth Circuit had that case and was determining whether or not the changes to the Fair Labor Standards Act was going to be proper. The Trump administration declined to prosecute or defend that appeal, and those went away. And then we got a modified version increasing the wage requirement for exempt employees. I'm not sure if that'll happen again, but we'll be keeping that in mind. Look forward to a future webinar where that will be discussed. Finally, I do want to point out, and I want to thank Michael and Christine for their leadership in this area and for their role. I want to thank Tammy, as always, the leader of the band, for running this committee and giving me the opportunity to be here. I want to end with one other thing, just so everybody knows. Much of what we're talking about applies whether the person is working in person or remotely, right? So all of these rules that we've been talking about apply whether or not somebody's hybrid, somebody's in person, or somebody is working remotely from their house. And so that landscape hasn't necessarily changed yet. And so please be aware. Sometimes I feel like people get, and my experience has been that people get accommodation requests and companies say, well, the person's working from home. What kind of accommodation do they need? We've already accommodated them. They're not having to drive. They're not having to come into the office. That is not the inquiry that needs to be made, right? The person, whether the person is in person hybrid or remote worker. All of the things we've been talking about apply and should be processed the same way, regardless of that status. And with that, I see we're at 12:58. We like to leave these on time. So I'll turn it back to Tammy for some final comments. Thank you all for joining us.
Thank you, everyone.
Thanks,
Well,
everyone.
thank you, everyone. And I can tell you that every time I meet Aaron and Christine and Michael, I learn something. And I cannot thank you guys enough for your talents and being here um, with us today. So thank you for your efforts. And this is an ongoing conversation. And as Michael pointed out and Aaron pointed out, if you please email if you have some questions that are going forward. But I want everybody right now before you leave to save November 15th. November 15th at noon will be a learning and development webinar. And this morning we have confirmed the head of Royal Caribbean and learning and development for that area, and learning and development for Florida Power and Light, and learning and development over with AvMed. So we have 3 great panelists and possibly a 4th, and the moderator will be named soon. So please save that date. You will get an invitation for that. And don't forget to take your survey. It's important for our community. And may you be blessed today and be safe. Thank you for joining us.